And thank you for joining us today. My name is Kara Orban, and I am a consulting librarian at the Montana State Library, and I'll be your co-moderator for this session today, along with Tracy Cook. And this is about meeting rooms and the library as a public forum. Our webinars and other continuing education opportunities are funded by the Institute of Museum and Library Services. Everyone in the participants panel is muted, so we encourage you to use the chat feature to ask questions and discuss with other attendees. And again, Tracy and I will be watching the chat, and we will share your questions and observations with Kris and everyone else as we go along. When you exit the webinar, you will be prompted to complete an evaluation, and we really appreciate your honest feedback on all of our continuing education offerings. So I'd like to introduce our speaker today. Kris Goss is the Director of Library Learning Hub at Helena College, University of Montana. Kris also serves as an attorney and currently works with the firm of Jackson, Murdo, and Grant PC in Helena. Kris previously worked with the Montana School Boards Association and served as a law clerk in the chambers of the Honorable Sam E. Haddon in the United States District Court for the District of Montana. Prior to law school, Kris worked as the governor's K-12 education policy advisor and deputy communications director in the administration of Governor Judy Martz. Kris earned a law degree from the University of Montana School of Law, a Master of Arts in Library and Information Studies from the University of Wisconsin, and a Bachelor of Arts from Carroll College. He serves as the vice chair of the Trust for Montana Libraries Board of Directors and serves on the Montana Library Association Intellectual Freedom and Government Affairs committees. And with that, I will turn things over to Kris.
Thank you, Kara. It's great to join you all and talk more about some operational and legal issues that are facing Montana's libraries. We're building on each week, we're building on the information we learned in the weeks prior. And this discussion about meeting rooms in the library is a public forum. And it goes back to our first session, but also builds on the issues related to patron behavior and conduct that we talked about a couple of weeks ago, as well as some components related to filming and recording in the library setting, as we discussed last week. So I'm going to share my screen so that we can pull up the slides for this event and get into some specific topics related to meeting rooms, the public forum, and library displays. So the first item we always like to start with is some intended outcomes. We're always seeking to build the confidence of library professionals, library officials in Montana, to ensure that you have the foundational knowledge to ask the right questions, the knowledge to handle a matter in real time, or to ask the right questions of an attorney or other public official that might be assisting or guiding the library. We're always trying to identify the emerging issues and as well as the traditional questions that may come with the topic area so that everyone feels that they can move forward with a good understanding of the law as well as operational best practices. So this is a little different than last week, the last couple week sessions with regard to the laws that apply to meeting rooms, displays, and libraries, a public forum. There aren't specific statutes that govern this particular issue. Instead, it's legal concepts based on the inherent rights that each of us have as citizens of the United States, documented in the Bill of Rights as well as in the Montana Constitution. And so starting with the First Amendment, one that all of us are familiar with, Congress makes no law respecting the establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press or of the right of the people to peaceably assemble and petition the government for redress of grievances. And then in the Montana Constitution, documentation in our Declaration of Rights in Article 2 of the Constitution, freedom of speech, expression, and the press. No law shall be passed impairing the freedom of speech or expression. Persons shall be able to speak freely and publish on any subject with the consequences that may stem from that publishing or speech. So what we have in these two these two constitutional provisions are the right to speak freely, as well as the right to gather and peacefully assemble. And in those situations, that gives each of us the right to speak our minds and to do so in areas that are available to speak our minds. But we also know that the First Amendment has an inherent component that means that people have a right to hear what we are speaking and hear what we are saying, a right to access information. They also have the right to reject what they're hearing and what they are reject what they're hearing from us or not listen to what we are saying. And so it's the concept of the marketplace of ideas that establishes that the concept of a public forum and what is a public forum and the different types of public forums and those forums that then create different legal standards by which the forum itself can be governed and regulated, and the speech that occurs within that forum being regulated as well. And so the different types of public forum that exist within the laws of the United States and the judicial opinions related to the concepts found in the First Amendment, the U.S. Constitution, start with a traditional public forum. The public forum that is the streets, the sidewalks, the parks, those areas that are traditionally known and held to be locations for the public to peacefully assemble as protected by the First Amendment, and then communicate, speak, listen to others speak, and engage in discussion in the free exchange of ideas and opinions in a peaceable manner that allows for discussions of the topics of the day in a way that allows people to express their thoughts, to learn about others' thoughts, to embrace their curiosity and hone their critical thinking skills. And so that traditional public forum is one that we know to always exist or typically exist in areas that are publicly owned and available for citizens to access. A limited public forum or a designated public forum is a different type of area that it has established and set aside intentionally for the expressive activity to occur, for people to engage in speech, for people to assemble. That's not in a publicly owned area that's generally accessible to everyone, but instead is an area that's established by the government for the access of information, for the ability of individuals to communicate with each other or express themselves. But because the government has established it solely for that purpose, and it's exclusively used for that purpose, there are expectations that come with the utilization of that designated public forum. A sidewalk, a street, a park can be used for a variety of different reasons, but a designated public forum, a specific place that the library, that the government rather has established for the exchange of ideas or expressive activity or access of information is an area, because the government has established it, is an area that may come with certain responsibilities, expectations, and behavior requirements in order for the expressive activity to occur. A non-public forum is a government building, government area, reserved space that serves a specific governmental function without the opportunity for citizens to engage in expressive activity. That would be in someone's office. That would be someone's private, not private meeting room, but set aside staff meeting room for that government agency. And that is not necessarily a designated forum. It's a place for the government to operate and for the means and methods of government to be employed and to serve the public without the potential disruption that can occur with expressive activity by the citizenry. When determining whether a forum is a traditional public forum, a limited public forum, or a non-public forum, they're going to look to the actions of that government agency. They're going to look to the policies that are set forth and adopted by that government. And they'll look to how the policies are enforced, how the policies are upheld, and whether or not the government is honoring its own expectations, governing its own criteria in the citizens' access and utilization of that forum. And so you may think about a county courthouse as being a public building, but the courtroom itself, is that an area where there is expressive activity to occur, or is that a non-public forum because it's established for court proceedings? Is the hallway outside that courtroom an area where there is the possibility of expressive activities to occur? For example, is the prosecutor, the county attorney able to hold press conferences in that hallway? Does that establish a designated public forum for expressive activity to occur? You can see how that type of use should match any written policy, and any use must be then consistent not only with the law, but with the established practice and the established written policy by that government agency. Is the lawn of the courthouse a traditional public forum? Is that a place where people can engage in expressive activity and communicate with one another, peacefully assemble without the expectation of behavior or conduct expectations? Or does the county have a specific policy saying that in order to engage in any type of assembly on the courthouse lawn, there needs to be a permit, or there needs to be adherence to expectations regarding consumption of alcohol or other ordinances that may govern the behavior of people while assembling on that public property? So you could see how a place like the courthouse and the different areas of that public property are going to dictate how that property or that space within the property is utilized. And if you expand that in order to analyze the specific settings within your library space or within the library property or facility, you can start to understand how the court would review any aspect or challenge to the library's assertion that the public forum laws may not apply to the speech that is occurring within the library. Depending on the type of forum is going to also dictate whether this is and how the court analyzes it. Is it a strict scrutiny analysis that the court will engage in, meaning there has to be a compelling state interest for someone's rights to speak or peacefully assemble can be curtailed? Or is it simply a rational basis test that the rules are going to apply? They're reasonably tailored to the operations of the library. For a traditional public forum and a limited public forum, designated public forum, you're going to see a strict scrutiny standard apply, because the expectation that the First Amendment right to speech and assembly has to have a very high standard, compelling state interest in order for that right to be restricted in any way. Whereas a non-public forum will be simply a rational basis test. Is that a reasonable rule that is reasonably related to the mission of the library, and as a result, the restriction on speech in a non-public area of a public building can be upheld by a court without being viewed violating someone's First Amendment rights to freedom of speech. And so that public forum piece is important when analyzing how the common area of the library, the meeting rooms within the library, the display cases in the offices are analyzed in accordance with the library's policies. So a library, school, or part of a library and school is typically designated to be typically believed or understood to be a designated or limited public forum. We've reviewed some of the cases in this area in week one when they're looking to the policy, they're looking to the established practice and making sure that the practice matches the policy, whether the agency or the government has, quote, designated the place not traditionally open to assembly and debate as a public forum. Has the library made that decision to say, yes, this is a designated area for speech to occur, for meetings to occur, for discussion and exchange of information to occur? Now, that's going to vary perhaps from location to location within the library, and that's why the written policy has to clearly outline what areas of the library may fit within each particular forum, and then making sure the practice that's utilized is consistent with that policy. The designated public forum, the Supreme Court finding that it's a place where the government, the state, has opened for expressive activity by members of the public. And it has to be a purposeful government action. There has to be a decision for that to occur. In some cases, the establishment of the library itself is deemed to be a purposeful government action because establishing that library and the common areas within that library are found to be developed for the purposes of accessing information consistent with the First Amendment. Now, does that mean that the person can stand in the library and engage in broad and wide, loud public speech within the common area of the library? That's going to then come back to the public libraries page and behavior conduct policy that we've talked about, and how the common area is distinguished from the meeting rooms and from the offices and from the display cases. And so when you think about it in those terms, the receipt of information that we've talked about comes back to the common area of the library, but also then to the meeting rooms, and not just the access of information that's held within the library's collection, but the access of information that can come. Is everyone able to hear me now? Kara, was there an issue with my volume?
No, sorry about that. That was an error.
No, that's all right. So when we look back to the practice of the library setting the policy of the library for patron conduct in the common area, that's one aspect of a designated public forum being a place where a compelling state interest is to ensure that everyone can access the library's services without disruption. And so that's an example of an expectation or a rule that allows for everyone to access information with minimal disruption. And that common area having that same standard apply to everyone consistently and equitably is important. But the library's decision to then set other areas aside for expressive activity comes with a separate and distinct policy that's going to vary slightly from the patron conduct policy that applies to the common area of the library where the general books and collection are housed. And so that's distinct policy sets the expectations and rules for those other areas of the library where those compelling state interests to meet the library's mission are established in accordance with a specific policy for meeting rooms and in accordance with the displays that are placed within the library itself. So the conduct and behavior expectations have to be consistently applied regardless of viewpoint, regardless of opinion or perspective. And it's important to distinguish between content and viewpoint. The content is going to be the topic, the subject matter. The viewpoint is the opinion on the subject matter or the topic. And so when there is a policy regarding meeting room and display cases, that is going to play a part in the legal analysis as to what the library is authorized to do in order to govern those spaces appropriately. So content-based restrictions may occur in areas where there are a designated public forum, so long as there's first a compelling state interest for a restriction on the content, on the subject matter, and that restriction is narrowly tailored to achieve that compelling state interest that the library has established as part of its mission, as approved by the library board and consistent with the state's laws governing library operation, and the question of whether there is a less restrictive alternative to the restriction in place. So you think about a content-based restriction. A content-based restriction could be a restriction on the ability of someone to utilize a library space for commercial purposes, whether they're going to charge admission to an event at the library and they're going to sell goods or services at the library. Is that a commercial enterprise that's occurring in a public space? And that's a type of content restriction that may be permitted because there's a government compelling state interest in order to restrict the use of the library to not-for-profit, charitable, or appropriate exchange of ideas rather than the utilization of public property for commercial or profit purposes. It's narrowly tailored to say that you're not charging admission to events at the library, you're not selling goods or services at the library, and you're having that operation done in a way that's the least restrictive manner, because it's equitably applied and it doesn't provide any exclusions for people that might raise questions of consistency in how the matter is being handled. That's different from a viewpoint restriction. A viewpoint restriction saying, well, we're not going to allow anyone who engages in speech about a particular function within the government, or not going to allow speech about a war protest, or not going to allow speech in support of war or opposed to war. You could have a designated public forum allowing for discussions on government actions such as a conflict or a war, but you wouldn't be able to then say, no, we're not going to allow those discussions to occur based on the viewpoints that are going to be discussed about that particular subject area. So the content and the viewpoint are important. Content-based restrictions could occur if there is that compelling state interest to meet the library's mission, but viewpoints about a particular part of the content or an aspect of the content would not be permitted. There also is the possibility of time, place, and manner restrictions, that the library is going to be open, during its normal hours. Meeting rooms may be reserved during this particular portion of those open hours. The manner in which someone can use a meeting room, or someone can use a display case can also be established, that they have to reserve those rooms or utilize the rooms in a way that's consistent with the library's operations and the efficient delivery of services to the patrons within the community. And so that's the conduct and behavior expectations that you would need to be mindful of when developing a library meeting room display case public forum policy that is separate from the general conduct policy that would apply to the common areas within the library outside of the meeting rooms. Display cases are an extension of this concept, because if you are offering display cases, which you're not required to do, but if you do have an area where the library does engage in displays of patron works, then there should be a policy outlining how those displays are organized and how those displays can be identified or selected, placed in the case. If it's always a library-sponsored event that's going to result in displays of patron work within the display case, then that can help simplify things, and it should be stated in the policy that themed displays that are organized by the library can be developed by the library staff, and they can review submissions consistent with criteria that are established by the library, so long as there's not viewpoint discrimination, but the content, the theme can be utilized in a way that's helpful to bring about exposure to new ideas, new perspectives, consistent with the library's mission, without running into a claim that there is a violation of someone's First Amendment rights by rejecting or not choosing to display those items. And so having those instructions, having a conduct policy that's integrated into a display case policy, making sure that any presentations or items that are submitted for display have to be consistent with the patron conduct policy, consistent with the directions and criteria established for selection. And that's a library-sponsored event that allows for selection and identification of items for the public to view. If the display case can be rented or reserved for community groups to utilize, then there needs to be a policy setting forth the expectations for how that display case is utilized, just as there would be for reservation and utilization of a meeting room. And so those restrictions, those directions would be consistent with the content-based restrictions that we've talked about and the criteria that would have to be established to ensure that anyone's display that is going to be placed meets those criteria in order for the library to confirm compliance with the law without engaging in any type of viewpoint discrimination. There can also be signage, and the policy could dictate what the signage would say, that this is the views of the group that has reserved the case for the month or the week in question, and that it is not the views of the library, its board, foundation, or staff. Then having all of that placed in a policy can then be relied upon, as we've talked about throughout our sessions, for the staff to make decisions that are then supported by the previous decisions of the library board, so that you have a framework in place for decisions that are supported by law and can be understood by the patrons. There are always questions that come up on meeting rooms, display cases that we frequently encounter as to whether the type of use is permitted by law. And one that frequently emerges is whether faith-based groups can utilize the library spaces. And this has been resolved through a series of cases. You can review those cases referred to as Liberty Council cases, where decisions by courts finding that faith-based groups may utilize library spaces, library meeting rooms, display cases, the same as any other entities, without entangling the library or the local government in their particular faith, as prohibited by the Establishment Clause. If you remember back to our first slide about the First Amendment, government shall make no restriction on free exercise of religion or not endorse any particular religion. And so when you have that concept and those two concepts found in the First Amendment, we know that people have the right to practice their faith. We know that the government is not going to endorse their faith. They're not going to make any policy that prohibits someone from practicing their faith. How does that all fit together when a faith-based group wants to utilize the library or its spaces? The courts have ruled that allowing that faith-based group to utilize a meeting room does not create an entanglement with that religion. It does not constitute an endorsement of that religion. And as a result, that faith-based group may utilize the library space the same as any other community group without violating the Establishment Clause. The same concepts can apply with political groups, ideological groups. They may access and utilize the library spaces in the same manner as others. to prevent that would be a restriction of their First Amendment right to engage in the exchange of ideas and peacefully assemble based on their viewpoint. And so that facility use will always be consistent with any behavior expectations that are established for the meeting room or for the library in general. And if there's a concern that the political group using the library or ideological group using the library would create controversy, that's not a sufficient basis to deny access. Now, controversy is maybe different from safety. Safety issues would have to be clearly identified, however, to demonstrate that there is a potential safety hazard to those that are being otherwise using the library but not attending the event, or safety hazard to the staff of the library. That's a careful set of analysis that courts have engaged in, but the concern or anticipation of controversy would not be a sufficient basis to deny someone access to the library because of their viewpoints. The library staff, when it comes to these types of events, have a careful set of rules to follow as well. That the library and its employees, volunteers, are providing the forum as a library program or service, but they are not providing assistance to actually deliver the speech or deliver the expressions or organize the assembly. Rather, the library staff is there to make sure the door is open, that the room is accessible, the lights are turned on. In order for the speech or the assembly to occur, the person reserving the room and organizing the display or organizing the meeting would have to facilitate the execution of that meeting. In other words, the library staff would not be the ones out front making the organizational decisions and organizing the meeting and facilitating how the meeting will occur and operate. That itself could be considered promotion of the perspectives that are being delivered at that meeting, and that in turn could be considered a violation of Montana's laws against public employees engaging in political speech. If a political party were to reserve a room, or if a group supporting a particular ballot initiative were to reserve a room, or a particular candidate were to reserve a room at the library for a meeting, and the library staff is the one engaged in behavior that could be seen as supporting that candidate, supporting that ballot initiative, supporting that party by facilitating the meeting and being the one that's helping organize the meeting, that could be viewed as a violation of those laws prohibiting support of political or ideological events, ballot initiatives, while on public time and in a public place. So providing the service, providing the room, but not providing services to support those that are utilizing the room. That commercial use function that I mentioned in the example before is something that has been reviewed by courts in other areas about the government restrictions on commercial speech may occur so long as they're not more broad than it's necessary to serve its substantial interests. And you think back to the example of someone selling goods and services or charging admission to an event at the library, that would be in opposition to the library's mission and purpose to provide free and equitable services to those patrons within the community that want to access information. And when those services are no longer free, as is outlined right in the title of the statutes establishing libraries in Montana, free public libraries, there can be a restriction on that type of content because of the library's substantial interest in promoting free and equitable access to information consistent with Montana law, consistent with the First Amendment to the U.S. Constitution, as well as the right to access information under the Article 10, Section 1 of the Montana Constitution. So looking to that example, you have those questions that can emerge. And we'll talk a little bit more about commercial use in a few moments, but it's one to keep in mind as a permissible content type restriction. So how does all this apply to your library's operations? Well, as we've talked about consistently throughout the last month, it is going to be based on your policy, and having a policy that is sound and consistent with the law and adheres to the concepts that we've discussed. Always supporting the mission of the library, always trying to balance the rights of each patron to access information where appropriate in a confidential way in a safe and welcoming facility, always making sure that you have a policy that refers to the other applicable policies that can govern patron conduct behavior when necessary, the recording and surveillance policies that ensure coordination. We don't want policies that conflict with one another. So when you update one policy to say what your new practice is going to be, or to utilize the new rooms that have been developed, you want to make sure that it is consistent with the other existing policies and update those as well. That there's not going to be any possibility of any viewpoint restrictions that may occur, that there's not going to be any confusion about how the use of this space matches with the mission of the library. The mission of the library is the compelling state interest that allows for any potential content-based restriction, time, place, and manner restriction to occur. And when that happens, then you're able to enforce the policy consistently, effectively, efficiently, allow the staff to make real-time decisions in a manner that's supported by the law. There also has to be an understanding that any criminal law is going to be promptly enforced. Any public records and public meeting laws are also going to be enforced. And so all of that happens, and all of it allows the library to make decisions that are legitimate, supported in law, and allow them to focus on library work rather than settling disputes about whether the policy is enforceable. So always looking back to the mission of the library, and the example that we've used the last few weeks of the fictional Mosaic Public Library serves each member of the community in a welcoming, secure setting as they pursue lifelong learning goals. Any meeting room and display case policy will be based on that mission, the compelling state interest to manage the library space in a safe and appropriate way, that it allows the staff to, authorizes the staff to direct individuals using the facilities, that they are going to identify those meeting rooms that are available, other reservable spaces that might be available outside or distinct within the common area of the library, and then establishing a process for those to occur, for the reservations to happen, when it can be used, the time limitations that may be necessary, and then complying with other policies that might exist within the policy manual, and then always integrating the patron conduct policy when developing a meeting room policy to help reassure the staff and other patrons that just because you've reserved your meeting room doesn't mean that you're able to engage in other types of disruptive behavior. So here's some examples of provisions for a library meeting room and display case policy. And what I've done here in this example, which you could utilize, but you'll need to customize it based on your specific needs, is list meeting rooms, display cases, and similarly designated spaces. And having that all in one area, you may divide it out into a meeting room policy and display case policy, but the concepts are going to be similar based on what we talked about in section 1 about right to free speech, right to feasibly assemble, consistent with the library's mission. Having that access and utilization of meeting rooms, display cases, and other types of reservable areas are all going to apply with applicable laws, regulations, policies regarding patron and employee rights, public records, and library operations. So that integrates all of those concepts we've discussed about the right to free speech, the right to peaceably assemble. You could delineate those within the policy and spell out that you're seeking to uphold the First Amendment to the U.S. Constitution, right to peacefully assemble, the right to engage in speech, that you're integrating the public records laws, the public meeting laws, the library operations that are all embedded in other parts of the policy manual. The library staff are not involved in the organization, management, or execution of the event. The director or the designated employee is specifically authorized to develop the means for reservation and how that reservation will be implemented and honored and could possibly be rescheduled or canceled, consistent with library needs and operations. Listing out those rooms, listing out the display case areas, listing out how they can be reserved, any additional equipment that is available in the room, the expectations and how they may differ from room to room based on the projector that's available in the room or based on the seating that's available in the room. Having all of that customized to the specific needs of the library. A damage provision that details how an individual may be expected to pay for damage to a library and how long they would have to make that payment and any recourse the library may pursue if the payment is not made. Making sure that a reserving individual knows that they're the ones that have to rearrange the furniture to meet their needs, that they could place temporary signage on the wall, but there is absolutely no permanent alterations to the room, the equipment, or the fixtures. And that the library staff, the director, and its designees are able to redirect, reschedule, revoke, cancel any type of reservation. And then they're the ones that are going to make any decisions about grievances or complaints. And that if there's a decision that the cancellation is necessary because of the group is too large or the time restriction is going to be exceeded or someone is misusing the space, damaging the space, exceeding the scope of the patron conduct policy, then the director is authorized to make those decisions. And then notification that because you've reserved a public space to engage in a public meeting, that reservation is a matter of public record, and you aren't able to hold secret meetings. You don't have a right of privacy as to your reservation and the details. And there is an expectation that others may be able to observe that meeting, know when the meeting occurred, review the reservation documents. All of those aspects of our public government transparency laws will apply to an individual who's utilizing and reserving a public space. Then some additional components to any type of meeting room display case policy, some specific expectations or restrictions, prohibitions based on what we've talked about. There is an expectation that the meeting will not be illegal in nature, that there will not be any violation of the criminal code. There's not going to be distribution of illicit drugs or harmful items. There's not going to be anything that would be considered a violation of the law regarding public order, disturbing the peace, disruption of a public meeting, obscenity laws that are codified in Title 45 that can also be utilized as a shorthand to prevent and restrict content that may occur within the library. The library is not in a situation where that type of obscenity can occur, where it would put the position of the library in jeopardy or the staff in jeopardy of possibly violating those obscenity laws as approved by the legislature. And so you also have the necessary ordinances that may exist within a municipality, or the regulations or other laws that can occur and exist that may apply to those types of those meetings. You would have the authority to develop a standard for anyone reserving a room to comply with library conduct and behavior policies. Those are going to be embedded and extended by reference into those meetings that occur at the library space or any type of display or exhibit. It's not going to place anyone in jeopardy of a harm because of the meeting that's occurring. You're not going to be able to have a disruption to the library setting because someone's concerned about the type of meeting that's occurring or engaged in any type of reckless, dangerous behavior For example, someone's not going to be lighting off fireworks in the room or utilizing explosive devices within the library's meeting room. So those are obvious restrictions that are developed for the safety of the library. And there's a compelling state interest to meet the library's mission to prevent that type of reckless and dangerous behavior. Interference or otherwise disruptive behavior to the library's operations, the ability of the staff to complete their duties, as we talked about a couple of weeks ago with the authority of the staff and to engage in their duties, and the criminal law preventing or prohibiting any citizen from engaging in behavior that prevents a public employee from implementing or completing their duties in their official capacity. Again, complying with all staff directives, that it is a publicly accessible area, may not exclude members of the public from the event or meeting, and complying with the building safety fire codes. You have those signs posted in each room that says the fire marshal has said 50 people can be in this room. We're not having 60 people in the room. If you're in violation of that, then you can be redirected by the library staff, or your reservation may be canceled. And then the commercial aspects, the admission fees, sale of goods, commercial enterprise, unless it's associated with the functions of the library or the library foundation. And that's a suitable exclusion because it's consistent with the library's mission in that compelling state interest to have fundraising opportunities for the library able to be implemented consistent with the mission of the library. So some other types of use that can occur when you visit libraries around the state, you see these sometimes come up. Is there a way for the library to be rented by a private individual for a private event? The use of the word private might be in question, but libraries do rent facilities. Public entities, public governments can rent the public space, and that rental agreement then specifies the time, specifies permissions, obligations of the renter. It obligates them to secure special event rental insurance to accompany the rental agreement. That the rental agreement will include provisions about comparative negligence, assumption of risk, that it can address alcohol use, marijuana use, address food service, or gambling that may occur as part of a charitable function, consistent with regulations in local ordinances, and can establish fees for cleaning, additional security staff, other services that may be necessary as part of that rental. And then the application of the patron conduct policy for any visitors that are attending that event, and that may occur. And so that can all happen, but it's going to be different from the library's general meeting room and display case policy, in that it is an added type of an elevated type of usage that would require a contract or an agreement and some additional insurance expectations. Your insurance carrier with the city or county may have standard language that is necessary in order to have these type of agreements in place, and I'd be able to assist in any of those as well to ensure a full compliance with the insurance coverage that you have, as well as any applicable county or city policies on that type of process. Some other libraries also have artwork from citizens in the area that is displayed in the library and is for sale. There may be a need for an additional policy on that that applies the patron conduct policy about not items that are being placed in a display case for people to look at, but items that are available throughout the library for people to potentially buy directly from the artist or the craftsman or person or business who's doing it. Is that commercial enterprise, and is it permitted? And that's why having a donation component to the library can help with that commercial component, meet the library's mission, make sure that the library staff is not the one that's engaged in the sale, that the details for contacting the artist to complete that are necessary. Any viewpoint restrictions are upheld and honored, and signage related to this is the work of a particular artist. This benefits the library. If you're interested, contact this artist. And then, policy reference to ensure that everyone's understanding that this is done in a transparent manner and allows others to pursue that same opportunity. Someone else wants to engage in that. You have a rotating monthly cycle or a list that people can get on to have their art placed in the library, or their works or their crafts placed in the library for sale, consistent with the private items for sale policy, with the donation to the library foundation. And then the assumption of risk that comes with, yes, your art can hang in the library, but if it's damaged, you're assuming that risk, and the comparative negligence statute applying to that operation. So those are two unique items that I've observed in libraries around the state. I just wanted to raise that might require an additional policy or conditional component to your policy. But these two slides give the framework for how there is the possibility for compliance with the library as a designated public forum that allows for individuals to access information, engage in expressive activity, both in the common area through the patron conduct policy, but in the designated spaces for meetings or displays throughout the library in a way that doesn't permit viewpoint discrimination or viewpoint restriction, and any content restriction is permitted because there's a compelling state interest to do so, and any time, place, and manner restrictions are also consistent with an established policy. And once the policy is in place, making sure it's updated, making sure it's consistent with the other applicable policies, and that the staff is trained to enforce the policy without regard to viewpoint or membership in a protected class. So that's a lot of information, and it's gone through it quite quickly. This is the helpline that we talk about each week. Chance for you to reach out if you have any questions on any of those legal issues. We'll be able to reply or direct you to those that might be able to assist and get the necessary information to help resolve any question that you might have in a timely manner. So with that, I'll close this off and let Kara or Tracy, are there any questions that have come in that I can address, or you might be able to address as well, or anything that I need to clarify or that I've confused because of a lack of clarity? Anything that people have?
We haven't seen any questions come in through the chat yet, but let's give people a minute or so to type in any questions, or feel free to unmute yourself if you have a question for Kris.
Yeah, anything that we need to clarify or that you're not quite sure about, like I said, because I wasn't clear, or anything that you were hoping to hear today that I didn't touch on.
And Kris, you might have covered this. This is Tracy, obviously.
Sure.
But I was taking copious notes and might have missed it. One question I have gotten with the faith-based use of meeting rooms is how to manage. It's not so much the content, it's the consistent, regular use. I don't know if you've gotten that question, like how you address that piece so that you're not discriminating.
Right. And that could be an issue that comes with any group. Yeah, but the faith-based groups may have it more frequently because of the routine, regular nature of worship or study of a particular faith that does happen perhaps once a week. In that can come up with other types of groups as well that want to engage in regular, well, this is our set time, this is how we're going to meet, this is when we're going to meet. Is there a way for the library to avoid the impression that it is setting aside those types of setting aside meeting rooms and times for those groups that allows for, or doesn't allow for, others to reach that same access or to have that same access? And is there a way for the library to set those types of equitable access? And I think the term equitable is important. People need to have a fair chance to reserve the room. And if the calendar is full a year in advance because one group has monopolized it. Is there a way for the library to set that? And I think you can set time, manner, place restrictions by having a process where you're not taking reservations for meeting rooms more than 60 days in advance or more than 90 days in advance. And so that's one way to address that particular issue. The other is the concept of whether the faith-based group if it is regular meetings and regular type of study, does that then constitute actual, like I said, worship, or does it go beyond a discussion and study and instead utilizing the library space as a place where the actual services are occurring? And the courts have analyzed that to a certain extent, saying it is not necessarily entanglement or endorsement of a religion, but can it still be considered use of a public space for the actual service or worship if it's happening in a regular manner? And that's something that the library needs to be careful of when working with those faith-based groups. If it is regularly occurring, if it is happening, each week at a set time, is the library becoming the place of worship for that particular faith? And that can create an additional level of analysis for a court and may create additional concern within the community, especially among other faiths. They're having to pay for a facility, and this group is utilizing the library as a publicly funded space without charge. Could that then trigger a rental agreement between the church and the library, where that regular use is occurring in accordance with that rental agreement? If there's a need for a temporary place for that service to occur, could they establish a rental agreement for that, and that would then transfer it from the free use or the nominal fee into a more formalized arrangement where there is that type of structure? The same concepts could occur if you have a 4-H meeting that's going to occur at a set time each place. Is that something that needs to be more formalized in a rental agreement? Possibly a conversation with the city attorney, the county attorney, or the library's legal counsel in order to make those determinations based on the current case law, to avoid the appearance of misuse of a public setting in a way that others may not gain access to, or creates an impression of endorsement of that particular group, entity, or faith. So an important question, Tracy, and one that might require additional analysis based on the circumstances.
Thank you. That's helpful. I had never thought of that possibility of a rental agreement, because I think it's that equitable access question and not
Right.
giving anyone an unfair advantage.
Exactly. And so that rental agreement possibility, one that exists, at any public entity, many public entities, I guess I should say. You can reserve the Historical Society, you could reserve the Capitol. There'd probably be a process for you to reserve the gymnasium at the school, or the high school or elementary school, processes to reserve parks for wedding receptions and different types of events. And so it's not a new concept. It might be one for your library to consider when having the possibility of more regular events, and a need for the library to protect itself, and the county or the city to protect itself by having that renting entity secure that additional insurance coverage to protect the taxpayer and to protect other citizens, and preserve the space for those more traditionally viewed types of meetings and events that occur within the library's meeting rooms and spaces. Other thoughts?
Other questions or comments?
Okay, thanks everyone. And I think we're taking a couple weeks off, and so we'll see you next month as we pick back up on our legal series. In the meantime, reach out if anything comes up, or if something that I've said creates a new question in your mind, or if you watch it again and think of something new. We're ready to help however we can, and we'll coordinate with the state library staff to get you the information that you need.
Thank you, Kris.
Thank you.
We will have the recording of this session posted to the State Library YouTube channel soon if you'd like to review the recording. And as Kris mentioned, the next session in this series will be on August 19th, and we'll be talking about children and minors in the library. So as you leave, please do complete the short evaluation survey if you have a minute. That helps us with our planning. And with that, thank you so much for attending. Thanks again to Kris. Everyone have a great afternoon.